Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of contract, especially matters involving that adverse inference cannot be drawn against a plaintiff in a suit for specific performance for not producing his passbook unless he was called upon to produce it. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Basavaraj vs. Padmavathi Anr pronounced on 5th Jan 2023, sale agreement was executed in favor of appellant for sale consideration of Rs 12,74,000. Rupees 3 lakhs were paid as earnest money. Thereafter, as respondent number 1 did not execute the sale deed, the appellant filed suit for specific performance. The trial court decreed the suit, holding that the plaintiff was ready and willing to perform his part of contract. On appeal, the Karnataka High Court set aside the judgment and decree passed by the trial court, mainly on ground that the plaintiff was not ready and willing to perform his part of contract. Being aggrieved, the present appeals have been filed. The Supreme Court has held that the findings recorded by trial court on readiness and willingness on part of plaintiff were on appreciation of entire evidence on record. In the legal notice, the plaintiff asked defendant to receive the balance amount and execute the sale deed. In reply, the defendant denied the execution of sale agreement. Thereafter, the plaintiff filed suit for specific performance, in which it was specifically averred that he was ready and willing to perform the agreement. In his deposition, the plaintiff specifically stated that he was ready and willing to perform his obligations. He further stated that he approached the defendant twice with balance sale consideration. There is no cross-examination in that regard. The plaintiff also examined PW 2 and 3, who were attestors to sale agreement, who specifically stated that the plaintiff approached defendants and asked them to accept the balance sale consideration in cash. To that also there was no cross-examination. The receipt of Rs 3 lakhs by way of earnest money was held to be proved by both courts below. Within a period of 1 month from passing of decree, the plaintiff deposited balance sale consideration before the trial court. The facts and circumstances of the present case show that the High Court erred in reversing the findings of trial court on readiness and willingness. The reasoning given by the High Court showed that the plaintiff did not prove that he had the cash to pay the balance sale consideration, as no passbook and bank accounts was produced. Applying the law laid down by this court in Indra Kaur and others versus Shiolal Kapoor, reported in 1988 to SEC 488, and Ramradhikar versus Dwarika Prasad Singh, reported in 1967, 1 SCR 153, to the facts of the present case, no adverse inference could have been drawn by the High Court. The High Court seriously erred in reversing the findings recorded by the trial court on the readiness and willingness. In view of the narrated circumstances, the High Court erred in quashing and setting aside the judgment and decree passed by the trial court. Under the circumstances, the impugned judgment and order passed by the High Court is held to be unsustainable, and the same deserved to be quashed and set aside. The judgment and decree passed by the trial court is hereby restored.